Minister.
Thank you, Madam Deputy Speaker. I join without reservation in supporting Martin's Law, and I think it is important that we salute the campaigning and the courage of Martin's family, and it is appropriate then that colloquially the bill is indeed named Martin's Law. What happened in Manchester was shocking and chilling to the core of us all, and of course reflective of so many acts of brutal, wicked terrorism that has been experienced right across this nation, not least in my own part of the United Kingdom. And here we are today, properly debating under the rules of due process and doing things in order, rules and laws to help us deal with terrorism. Conscious, of course, that terrorists play by no rules. They do not live within the confines of regulation or restraint or anything which would meet the standards of human rights. Quite the reverse. And to that extent, society as a whole struggles because of its determination to live within the rule of law, struggles on occasions to deal with the excesses of terrorism. All the more reason why we need to do all and everything we can, even in the small things. And this bill, I suppose, in the main, is about the small things of dealing with terrorism, to try and put ourselves in the best possible position to deal with the potential and the threat which exists sadly across this nation of terrorism. And in doing that, of course, I think we have to be realistic that all the dots and stroking all the T's is good, it's necessary. But fundamentally, terrorism will only be defeated across this nation when there is no room for terrorism, when it meets the full rigour of the law, and when that rigour of the law puts it out of business. That is the fundamental reality of all of this. I do, though, want to make a few comments about some of the particulars of this bill. I do have some concerns about its potential overreach. The Honourable Member for North Cornwall touched on some of this. Small schools, small churches, now subject to further regulatory requirements. I chair a board of governors of a small country school. We already have to have policies on fire safety, on health and safety, on dealing with emergencies. All good, all necessary. But in this bill, I'd like the Minister to explain what is the practical addition that's going to be put upon, say, small rural schools and their boards of governors, as to what it is they have to provide that they're not already providing in their emergency policies, in their fire safety policies, in their health and safety policies. I think boards of governors in particular will want to know that, and will particularly want to know that when they operate within very, very restrained budgets. Every penny, I know in the school I'm involved with, is accounted for, is needed for the fundamental provision. And I am concerned that this bill, in its global approach, might put upon very small users unbearable bureaucratic and financial burdens. I noticed that the impact assessment said the majority of the costs will fall upon the businesses that have to operate it. That also means the majority of the costs will fall upon small schools, small churches, small community organisations, and all the rest of it. And that is a concern that I would have some worries about. Earlier in the debate, an honourable member made the point that what would this bill do to deal with the situation often deployed by terrorists of previously planted devices. And it's hard to see how, without reaching into physical acts being required as counter-terrorist measures, how it would in fact impact. And I make that point mindful that just this weekend we marked the 40th anniversary of the Brighton, the Grand Hotel Brighton bombing, where one of the most audacious terrorist attacks to kill the cabinet of the United Kingdom was perfected by the planting of a bomb weeks before in that hotel. So we need to consider what is it that would help deal with that situation. That's why I'm a little bit concerned that in this bill, the Home Secretary said there will be no measures requiring physical steps to be taken. Well, if you have an hotel, if you have a leisure centre, if you have a large arena, and there is a deficiency which is observable by the SIA or whoever else in their CCTV coverage, as there was in Manchester, the terrorists were cute enough to pick out the blind spots on the CCTV. So is it not sensible, moving forward, if we're going to put in place protective measures, that they could include, should include, physical measures such as identifying the gaps in CCTV coverage so that in the event of an outrage, there at least is the better prospect of bringing to justice those who perpetrated it, and perhaps acting as a deterrent. Because very often in fighting terrorism, deterrence is as important as anything else. And I do think it is our duty to ensure that that is so. I want to just touch a couple of other points in the bill. I note in clause 31 on civil liability, it says, nothing in this part confers a right of action in any civil proceedings in respect of any contravention of a requirement imposed on any person by this part. That causes me to question. Most of all our buildings are covered by the occupiers' liability legislation. The occupiers' liability legislation is premised on the duty of care of the occupier to their visitors. How can we say in clause 31 that if we're going to impose obligations in respect of taking steps to protect against the potential of terrorist attack, and those steps are not taken, how could we say in clause 31 that that will not create the basis of civil action? Surely that is an indicator and a contributor to the question of whether or not the duty of care was fulfilled to the visitor. So it does puzzle me why clause 31 is in those terms. The final thing I wanted to say is in respect of the SIA. We are giving a lot of powers to an organisation which frankly has not always covered itself in glory. I speak of my own party, the United Kingdom, where we have had licences issued to some dubious characters by the SIA, and it's not beyond the wit of terrorists, and some of us have seen this, to set themselves up as so-called security firms and apply for licences. Do not ever fall into the trap of thinking that terrorists act by the rules we would act by. They wouldn't do that. Yes, they would. And the SIA, I think, has been found wanting. And in Northern Ireland, we recently had a case of gross overreach by the SIA, where they brought a prosecution in circumstances where the judge said it had to be stopped, it should never have been brought, and they spent £200,000. And they involved in that illegal searches of property. So the SIA is not a body which I think is the ready recipient for these extra powers. And I do worry that we are going to overburden it if they're going to do the job in the way it needs to be done. So I do say to the Minister, maybe the SIA is not the right regulatory body, because they already have a huge burden of work and have not always been successful in that what they do. We want to get this right, and we want to get this right by making sure that we, the elected representatives of this House, wanting to protect our constituents from the most hideous of things, namely terrorist attacks, do all that we reasonably can. And that means getting this legislation right. Thank you.
Well.